Good morning, everyone, and thank you for joining us and a very warm welcome. I'm delighted to be hosting this webinar, the latest in our How We Live Sustainably series. And today we're focusing on biodiversity net gain. My name is Anjali Bancroft and I'm a Principal Associate in our Housing and Regeneration team, focusing on helping developers acquire and dispose of land for residential development. I'm joined today by our presenters. Firstly, Ben Stansfield, a sustainability partner in our planning and environment team. Ben is advising a number of our clients, house builders, logistics and renewable energy developers in relation to the risks and opportunities presented by biodiversity net gain, and is currently advising on the creation of a number of offsite habitat banks, therefore dealing with many of the practicalities as to how BNG is to be delivered. We are also joined today by Ed Colreevy, a partner in our housing and regeneration team. Now, Ed advises house builders and developers on acquisitions and disposals, and alongside Ben has spent some time speaking to our clients recently in relation to practical implications of biodiversity net gain for transactional work. So our topic today is BNG. We will look at the mandatory requirements coming into force, the recent government guidance from February 2023, and the practical implications for compliance. Now, just a few points on housekeeping before we start. As this is a webinar, you may see that the chat function has been disabled. Now, we have planned in some time to answer some of your questions at the end of the presentation. And if you do have questions, please do feel free to use the Q&A function as and when these questions arise, and we'll look at them at the end. Now, if we don't get to all of your questions, we're more than happy to follow up. So if you want to drop your contact details, we're more than happy to follow up with you after this session. We will be recording this session as it's a webinar, and we'll be looking to circulate that following the end of the session, and it will also be uploaded to our website. The session is planned to run for about an hour, so till about 11 o'clock. And now I will hand over to Ben to start things off.
Thanks, Anjali. Good morning, everyone. Welcome to Stansfield Towers here in Essex. I would be in the office with my colleagues if it were not for the train strike, but never mind. So I'm going to talk to you about BNG. I'm going to cover some of the regulatory and planning issues, and Ed will deal with some of the transactional and sort of the meaty deal specific issues. I'm going to set the scene today by telling you why biodiversity matters with one of my favorite graphics from the World in Data website. And this is a global image, and it tells us really why we're in a biodiversity crisis. So 10,000 years ago, the world was lovely. You know, we had nearly 60% was forest, 40% of our usable land was grassland. I mean, obviously we have deserts, glaciers, terrain, all that kind of stuff, unusable land. But the land that could be used for growing stuff was grassland and forest, and it was lovely. About 5,000 years ago, we built the pyramids, we started to farm, and it's been slowly degrading, I guess, since then. So if you look at our 2018, 2019 figures, we don't have anything more up to date than that. You can see that we have lost a third of our forest, and we have lost nearly 3/4, give or take, of our grassland. And we've replaced that with buildings and agriculture. So if anyone ever points the finger at the development industry and says, oh, it's the developers who've destroyed biodiversity, you can actually see only 1% of our land is urban and built up, and that's globally. I don't have the UK figures. I appreciate that would be even more insightful today, but 15% of our land is used for growing crops for human consumption, but a third of our usable land is for animal agriculture and grazing and producing crops for those animals as well. So you can see, very visually why we are in a potentially biodiversity crisis, and how we're using land. And the whole purpose of the biodiversity net gain policy regime is to start replacing some of that lost biodiversity. We might not be able to replace the land, but we can certainly improve nature that was previously with us. Right, so that's the scene beautifully set, I hope. Onto the basics. So the biodiversity net gain regime will start for most developments in November this year, which means you need to start thinking about it now. If you have a large application for planning permission that you're putting together that is likely to get planning permission in November or subsequently. If you've got a smaller site, and we can talk about the split start, if you like, for BNG, some of it will start next year. If you've got a small site, so up to 9 residential houses, or if you don't know how many houses you're building, if you've got half a hectare or less, then you're a small site, and this all kicks in for you next year. But you will be required, as a result of, you'll be required to improve biodiversity by 10%. So you take a baseline, your pre-development baseline, you work out what the biodiversity value of that site is, and then you need to improve that sort of like for like or better for like improvement by at least 10%. The biodiversity value of your site will be measured using a DEFRA metric. We're currently on metric, I think, 3.1, and the recent response to government consultation, the guidance which was published in February, there's talk about having a biodiversity metric 4.0. So changes are afoot. The biodiversity metric is I sort of joke that it's way beyond my pay grade. You will need a very competent and a qualified ecologist to help you evaluate the biodiversity value of your site. It's pretty complicated stuff, and I know the groove in which I sit, and the metric ain't it. Really important to get our heads around the difference between units and credits. So you will need to, as I say, work out the biodiversity value of your site, how many units that is. And you'll need to create or acquire biodiversity units, so either on your own site or off-site. If all else fails, there is a sort of an in case of emergency break glass solution, which will be buying biodiversity credits. So there's a statutory credit regime where the Secretary of State you can buy credits from the Secretary of State and use those to satisfy your obligation if for whatever reason the planning system slows you down. So there is little chance of the new regime slowing down development in that sense. Additionality. So what do I mean by that? And we'll talk about stacking in a minute, but additionality in this sense means that, so if ordinarily to get your planning permission, you would need to do some landscaping, let's say, or create a sang or something like that, create some open space. That can't be used for biodiversity net gain. So biodiversity net gain needs to be over and above that which you would ordinarily need to provide or do in order to secure planning. So that's additionality. The government is alive to the fact that some folk, not necessarily obviously on this webinar, but some folk might be tempted to degrade the biodiversity value of their site prior to getting planning. So deliberately reduce the biodiversity value of the site in order that 10% is easier to obtain. Government are alive to that. There will be rules, there will be regulations rather addressing this point. And essentially any site degradation will be taken account of, and so that we'll probably go back to I think it's January or April 2020, which is when the Environment Bill, which is the framework legislation for the BNG rules, that's when that sort of came back into Parliament for consideration. So January 2020 will be the key date there. Maintenance. So the biodiversity works that you provide will need to be maintained, will need to be provided and maintained for at least 30 years. So really quite a long time. And that has sort of implications on cost, liabilities for landowners, all that kind of stuff, which we'll talk about shortly. A biodiversity game plan will need to be submitted to the local planning authority as part of either your application or prior to commencement. And there is a condition which I think I'll flash up in a moment, which will be deemed to be included in all planning permissions granted from November 23. And that potentially raises a JR risk, which again I think Ed will cover subsequently. And how will these wonderful works that you're going to do, be secured? Well, there is at the moment Section 106 agreements will be used for BNG works, but there is also a new regime, the Conservation Covenant regime, which is within the Environment Act. And I've got a few slides on that in a moment, so I'll talk about that in a minute. So that's the legal mechanism will be used to secure, in particular, the 30 years maintenance. So I talked to you a minute ago, I referenced the condition which will be imposed. So the Environment Act says, planning permissions will be deemed to include a condition which says that development may not be begun until a biodiversity game plan has been submitted and approved by the local planning authority. I suspect in reality that condition will be very expressly included in that plan, sorry, in the permission. Okay, so the government consulted on BNG last year for 12 weeks. I think the consultation ended, I think, sometime in April. And we've been waiting for a response to that consultation since. That response was published at the end of last month. Very exciting. I know a number of you have probably been waiting for it. And I think, I think opinion's been split, right, on the response that government issued. I think there are a number of folk, perhaps myself included at one point, which thought that the response might be a little bit more detailed. We'd have a sort of an inch or two thick document, which we would all have to wade through. And it was a little bit thinner than we expected. And I guess we hoped that, the 12 or 24, however many questions we had, would all be answered. And a number of them were. A number of the really important questions were answered, but there are still gaps. We're still waiting for draft regulations to be published. And do bear in mind that the things I'm about to tell you, the outcomes, the exciting news from the response, that has no basis in law. So we need the regulations to crystallize, to give teeth to the comments in the responses, and I'm sure that will come. And actually the response is helpful because it says, look, we're going to tell you a bit more about what a biodiversity game plan needs to include. We're going to tell you in the coming weeks and months what a really good conservation covenant or 106 obligation needs to include. So we know roughly what's coming. We don't necessarily when it's going to come, but I think what I take from this is that DEFRA is being quite careful to make sure that it has a really workable scheme. Yeah, this is going to apply to all developments. This is really important. They can't get it wrong. They can't be sort of, getting to December at the end of this year or January, February next year and saying, oh, crumbs, actually, we need to tweak the scheme because it's not quite working as we thought. So I think actually, although a little bit frustrating for some developers now who are wanting all the information, I think in the long run, this is a really good approach that DEFRA is taking. Okay, so what are the highlights of the response to consultation in the guidance? Well, a lot more money for local planning authorities. So a lot of the local planning authorities that I've been chatting to have obviously, they're lacking funding. Resource is always an issue. This is a big thing for them to get their heads around. So there's a fairly substantial check that's going to come their way to help them tool up for this. There is a shortage of skills and understanding throughout. With developers and the authorities as well. So additional funding, which is good. A de minimis exemption. So if your scheme is only impacting, let's say, a 5-meter hedgerow, then you won't need to provide biodiversity net gain. If you are impacting a small bit of land, so 25 square meters or less, you won't need to worry about biodiversity net gain. And I get that that's practical. I fully understand that it makes the scheme workable if there's some really tiny impacts. But the tree hugger in me is a little bit disappointed by that. And I think maybe that whilst you might not strictly need to comply with BNG, just something to be, I guess, to bear in mind that, for developers, that the optics of being exempt might not necessarily be favourable in the communities, and notwithstanding you don't need to sort of be fully in the BNG regime, you might want to think about something that you could do instead. There are exemptions from certain types of development. So if you're undertaking development through the permitted development regime, you don't need to worry about BNG. If you are doing some householder development, so sticking on a conservatory, doing something to the roof, all that kind of stuff, you will not need to worry about BNG. If you are creating an off-site habitat land bank, more on that in a minute, you will not need to create or you will not need to provide additional BNG. That would be kind of BNG on top of BNG, so that would be a little bit odd. Similarly, there is it's not an exemption, but they talk about a sealed surfaces. So if you have a site fully tarmacked, then your biodiversity, your the DEFRA's biodiversity metric will give that site a 0 score. So in a way, you're exempt from that as well. So a few things to think about there when you're looking at your schemes. Irreplaceable habitat. So this beautifully sort of beautiful approach in guidance that they say irreplaceable habitat won't be covered by BNG, and the definition of irreplaceable habitat will follow in due course, and we'll consult on that. I think what they're trying to get to here is, I suppose, a bit like the HS2 development. So development which impacts ancient woodlands, things like that, stuff which is, I guess, irreplaceable. So that won't be subject to biodiversity net gain, but will be kind of subject to almost a parallel regime where appropriate compensation will need to be given. You'll need to provide a lot more detail in your planning application, additional reports, analysis, and that will go into the mix for the local planning authority to think about. So it won't be subject to the BNG 10%. It will be subject to something else, and probably far more scary, involving many more meetings and discussion with planning officers. Phasing has worried a lot of us. So if you have a large outline plan permission and you're going to deliver your scheme in a number of phases, what does that mean? What does that mean for BNG? Does it mean you're going to have to do it all in phase 1? Can you put it back to phase 4? And DEFRA have said in their response, look, we get it, we understand it's an issue, so we're going to want a biodiversity game plan still, and we will want you to provide an updated biodiversity game plan for each of the phases that you're going to come forward. There's a little bit of frustration, I guess, in the response for me, in that the DEFRA say, well, we don't want to create any hard and fast rules. We don't want to create inflexibility. So I think there will still be discussions with officers, and one or two officers may rightly dig their heels and say, well, we do want some early biodiversity gain to be provided in phase 1, perhaps a little bit more than you might be comfortable with. But there is a recognition in the response that if you've got complex infrastructure arrangements and it won't necessarily be possible, there won't be an absolute requirement for 10% in every phase, but they will want to know what's going on. In that sense, it feels to me a bit like a travel plan, that you produce this framework travel plan, and then before you really start, you give a bit more detail as to how it's going to really look. So I think I think overall that's developer friendly. Section 73 applications. This was again a worry that if you had a plan permission, let's say granted this summer, prior to the biodiversity net gain regime coming into force, before you have that mandatory 10% requirement, if you then need to change your scheme, if you need to tweak your development and get a Section 73 planning permission, so a new planning permission, let's say early next year, that would be in the new phase, but the original permission wouldn't. What then? How do we do baselines? It strikes me, or reading between the lines, there was quite a bit of debate on this internally with DEFRA. What they've ultimately decided is, if the original planning permission wasn't subject to BNG, then your Section 73 won't be. So in my example, get your planning permission before November. Subsequent Section 73s won't need to comply with mandatory biodiversity net gain. That's a helpful thing for developers. I've hinted, or I've talked a little bit already about the small sites delay. So if you're developing up to 9 homes, you don't really need to think about biodiversity net gain until April 24. I guess that's just keeping the development industry sane, keeping officers sane as well, that they don't need to worry about that. They can just focus on the bigger schemes at the moment. NSIP, so the Nationally Strategic Infrastructure Project, so probably not applicable to many of us on this on the call today. That will be subject to BNG, but not until November 25. Okay. What else? Biodiversity game plan delivery. Sorry. So again, a discussion in the response about when does the biodiversity game need to be delivered? When do we need to do these works? And there has been talk of needing to provide the biodiversity works within 12 months of commencement, possibly prior to occupation. And again, the response said, look, no hard and fast rules, each case on its own merits, all that kind of stuff. Have a proper chat with the officers, work out something sensible. So there is flexibility here. So again, if you have complex early stage infrastructure works you need to do, then there is support in the response and the guidance to help you. Let's see what it says in the regs. Again, I'm going to talk about offsite habitat banks in a moment. There's a clear expectation that a number of local planning authorities will be creating their own habitat banks. And I think one or two cynical folk, myself included, expected to be in a situation where you've got your planning, you've got your development scheme, you go to the planning authority and they say, well, we'd really like to introduce you to our estates team who are running their own habitat bank. Possibly you could get your units there. Wouldn't that be nice? And that might, make your planning application go through a little bit more easily. So the government response is, well, look, no, you can't do that. Local authorities can't direct any developers to their habitat banks unless there are clear ecological justifications. I suspect what they mean here is if you're after a certain type of biodiversity unit, you're trying to get a particular type of grassland unit, something like that, then that would be an obvious reason to use the local authority habitat bank. But there is to be no dodgy dealings, let's say. So that's good. I was surprised to see this in the response, excess gains. So if you are a developer, if you're a landowner and you put in more than 10%, so let's say you've got your housing scheme and you do 12% biodiversity net gain, the response makes very clear you can sell that 2%. You can sell the excess gains. I think a number of us thought that was fairly obvious, but I guess it needed to be clarified. That's fine. You can do that. Registers. So what we've got here, offsite only. So there will be a biodiversity offsite register, a biodiversity site register, which will be managed by Natural England. That will only include on it the offsite provision. So if you're providing biodiversity works on your development site, you won't be on that register. That seems a little controversial. That seems to be causing some disappointment amongst let's say the ecologists or the non-development world. I suspect that might change. I think we will end up with a register where all the information about all the different biodiversity bits and bobs will be on there. But watch this space. Secretary of State credits. I've told you, in a case of emergency, if you can't provide biodiversity on site, if you can't provide or get easily your units from an offsite provider, you could go to the Secretary of State and buy the credits. The response to guide consultation says the price of those credits will be intentionally uncompetitive. When the market for biodiversity units is up and running and it's all running smoothly, I think we can expect that credit regime to be withdrawn. The Secretary of State doesn't really want to get involved with this, but is providing this solution of last resort. Prices will be published, I think, 6 months in advance. So we will know, you can put in your development model, your appraisal models, what the cost might be of satisfying biodiversity net gain rules, because you can put your Secretary of State credit price in there, but hopefully you should be able to get it cheaper. Stacking, this is cool. So if you have got a biodiversity site, you've got subject to the BNG regime, you can use that for other things. So if you want to use that for nutrient neutrality credits as a landowner, you can do that. You can't use it for carbon sequestration, but you can work your site as a landowner. You can do a few things with it. That's really good. That's going to be very popular. And then finally, in the response, they say, look, regulations, will publish them later in 2023. So I have no doubt that Ed, Anjali, and I will see you again for another webinar in future. And again, the response says we're going to produce more guidance. So particularly what a biodiversity game plan needs to look like. Also what a conservation covenant needs to look like as well. So one of the big questions is where to deliver your biodiversity net gain. Is there going to be a hierarchy whereby you start on site and then you sort of go down all the way through the options to Secretary of State? And that probably is right, but I still can't really look any of my clients in the eye and tell them exactly when they can move from one to the other. And I think this is going to be a topic. A number of planning officers are going to say, a little bit like they do with affordable housing, the starting point is you provide that on site. That's where the impact is, and that's where we want to see the works. And I get that, but it's not always going to be the most, well, firstly, it's not going to be the most practical, and we'll go through a few examples. And secondly, it might not be the best for nature. It might not be the best biodiversity solution. You know, we might find that in many, many cases, the offsite habitat land banks are by far and away the better solution. But there's going to be an education process to go through. There's going to be discussions needed with officers, and this doesn't actually, this quote here isn't from the guidance. This was from the press release with the response, and it just, to me, creates you know, it's just vague, right? So it says, well, look, you know, we'll encourage improvements on site, but there may be circumstances where that's not possible. So again, as I say, I think this is going to be something where we discuss with officers quite a lot. So where might you do your biodiversity gain works? Probably not a solution that many out in the shires will need to adopt. But if you're doing student accommodation in an urban location, you know, you might have a small constrained site. And you might find that the local planning authority are really pushing you to do a green wall, a green roof, something like that, whereby you can have some biodiversity compensation, let's say, on site. Again, I think that's potentially problematic, right? Yeah, that's extra cost. That's all sorts of unpleasant and difficult maintenance. But we might find ourselves there. You know, if you're a logistics provider, I know it shouldn't be too many logistics folks on this site, but you know, if you're doing last mile logistics, that's going to be quite a difficult. You know, you have a nice big roof. It can be quite an expensive structural improvement that you need to make, and all sorts of maintenance issues to deal with as well. So I think on site or on structure solutions, challenging, but they look great. Okay, where else might you do it? So if you have got your housing scheme with your, you know, within your red line, you might be pushed, or you might want to be doing your biodiversity gains works within your red line site. It will look great. It might not be the best biodiversity solution. Let's put ourselves in the position of a bee. If you're a bumblebee, where would you rather go? Would you like to go to the housing estate where there are, let's say, 200 homes with 2.4 kids in each one, and there's a dog, everyone's got a cat which is trying to attack the local wildlife, there are going to be cars coming and going? If you're a bee, would that be your first choice destination? Possibly, possibly not. You might prefer to go to an offsite habitat bank where, and the argument here is, you know, 2 + 2 + 2 + 2 gets you far more than, or how many twos that was. Yeah, it gets you in aggregate a much better biodiversity solution. There are going to be no cats. There are going to be no cars coming and going, no kids kicking their football into the wildflowers, all that kind of stuff. But again, local authorities may say it's got to be on site. And there are some issues there around, you know, how you pay for the maintenance, how you do the estate management. Okay, so you might want to do it on your blue line land. So you might have your red line site, and you might say, well, we're going to put it on our blue line next to the resi, next to our housing estate, next to our development. Why? Because it looks like it's on site, so it kind of ticks that local mitigation box. We might control the site, our landowner might control the site, so there's a relationship there, there's a nexus there that might make it easier. I think this is a solution that works really well, perhaps not so much in the resi space, but perhaps in the living space, I should say, maybe more for the energy and infrastructure. So we've been talking to renewable energy clients about, well, if you want to produce lots of solar farms or battery storage, maybe it's quite good to have your biodiversity nearby, possibly adjacent, but in a slightly separate vehicle, so you can sort of put all your infrastructure assets into a fund without this question mark as to what the long-term liabilities might be. You could do offsite. So if we can't do on-site, or we can't do next to site, we could do offsite. So you might own land or lease land a few hundred meters away or a mile away. I think once you start moving outside of the local planning authority, once you move out of that administrative area, there's a possibility of a bit of grumpiness from local, from objectors, I guess, and from planning officers. And also the biodiversity metric is going to punish you. The further away you go from your development site, the more biodiversity units you're going to need to create or acquire, whatever. So offsite is a potentially good solution. And I guess it means that you can maximize the densities and so forth. You won't have to take 10 units out of your scheme in order to do the biodiversity works. A good solution, I guess, if you're doing a number of developments in a region or in an area, and you could perhaps do all your biodiversity works all together and again get that aggregation. So off-site habitat land bank. So for example, the Environment Bank are really leading in this. Do check out their website. They are creating off-site habitat banks in each local planning authority. They'll have a team of expert ecologists and folk doing the management. So it's a really good sort of trusted, the argument is that there'd be a really good trusted third party who can take care of your habitat or your BNG requirements for you. And it removes the maintenance, it removes the discussion with landowners, all that kind of stuff. And it should be local to each of the schemes. So we're seeing those new assets cropping up. Similarly with local planning authorities, we've already mentioned that they might start doing stuff. It will be a good revenue spinner for some local planning authorities. So that's a new model we're seeing crop up. And then finally, in case of emergency, break glass, buy something from the Secretary of State. So if you're building your McMansion, for example, you might just think, well, you know what, it's far easier to just buy credit from the Secretary of State. I don't want to do it on site. That might be a solution for some people. Okay, so how are we going to secure this? Conservation covenants. I'm kind of making an assumption that many of you will be familiar with the 106, so I don't really need to tell you how 106 works. A conservation covenant is a new legal instrument established in the Environment Act 21, and it can be. The idea is it will be used for perhaps listed structures, so listed buildings, as a means of conserving them, but I think fundamentally 99% of them will be used for biodiversity projects. So these are a little bit like 106. So contractual agreements to secure the long-term conservation of sites. Unlike a 106, which is with the local planning authority, the agreement with a conservation covenant will be given by a landowner or those with interest in land to a responsible body. And I think DEFRA in its mind has the idea that, yeah, sometimes these might be local planning authorities, it might be a local wildlife trust, someone or a body rather with real expertise, perhaps in a certain type of habitat or in a certain administrative area. We don't know entirely what the criteria for being a responsible body, what those criteria are. And so no one's come forward and said, yes, I will be a responsible body. Please sign me up. I will start receiving the benefit of these conservation covenants. Again, cynical Ben says, well, are we going to find that local bodies, local nature groups apply to be responsible bodies? Perhaps people who don't have as much familiarity with enforcement as a local planning authority would have. So there's a bit of a fear, I think. I mean, it's the fear of the unknown, isn't it? It's crumbs. Is this responsible body going to be coming around to my site every day saying, oh, those flowers haven't, they've not probably germinated, oh, the daffodils haven't come up, all that kind of stuff. Or I did a count and I couldn't see any bees. So you need to come and start, we need to start enforcing all those kind of silly hair trigger enforcement I think we worry about. So at the moment, we're seeing all this stuff pushed down the 106 route. I think that will change, however. The idea of conservation covenant will bind landowner, will bind subsequent landowners, and they're going to be onerous. It isn't going to be an easy solution. These will be strict, and let's bear in mind the whole point of BNG is to enhance nature. So that's the point, and all the obligations will be aimed at doing that. So what kinds of things might we see in the conservation covenant? So covenants to create it, to manage it, to maintain it in accordance with an approved plan. Security is a real question mark. How are we going to deal with that? How are we going to demonstrate both to our landowners, and particularly to the responsible body, that we've got the funds to do this for the next 30 years? If there's storm damage in year 10, how are we going to prove to them that we've got the funds to sort that out? So that's going to be a big question mark. We're going to have to do monitoring. We're going to have to have indexation of monitoring payments, for the local authority in the 106 regime, or for the responsible body to assess the works we've been doing. Are we going to have step-in rights for an off-site developer? Probably not. I think that's going to be entirely unacceptable. But developers might be worried about their reputation there. Again, I've sort of hinted at, what's going to be a fundamental breach, what's a material breach, what are the remedies. Ultimately, a conservation covenant under the Environment Act, the responsible body can get an injunction. So this is pretty serious stuff. What if you want to modify your conservation covenant or your 106? Should that mean the local authority should have a right to look at it? It's unknown. It's a bit of a worry. We look forward to additional guidance in this respect. And then just finally, before I hand over to Ed, I just want you to talk about some of the different sort of stuff that we're coming across our desk. Biodiversity Net Gain is producing or throwing up a whole new world of work for us all. So we're going to have more additional reports, different assessments that form part of our planning application. We're going to have to include draft biodiversity game plans, and we don't know entirely what will be in those. New legal agreements, habitat bank leases and farm business tenancies are being used to deal with BNG. Habitat management agreements are coming across our desk quite frequently now. We're looking at those quite a lot. Those will be the relationship that gets the actual work done between landowner and developer or offsite provider. Conservation covenants and 106s, they are going to be pretty meaty. Lots of detail in there. And again, getting landowners comfortable or that they can sign up to them is going to be a challenge. We're seeing unit purchase agreements, and again, those seem to be based on the sort of the emissions purchase, under the carbon credits regime that we've looked at many years ago. So we're starting to see the unit purchase agreements. And then neatly segueing into Ed, options are a key. Biodiversity net gain is a key issue for options. So Ed.
Great, thank you very much, everybody. And the eagle-eyed amongst you might have noticed that halfway through your environmental talk, Ben, the lights dimmed in the office in which I'm sitting. So obviously we have an environmentally friendly environment in which to work. So thank you very much for that. That's really helpful and insightful as ever. As you can tell, Ben is really passionate about everything to do with environmental matters, particularly BNG. And that's the genesis really of my input in this. So this all started out with me talking to Ben and speaking to some of our housing developer clients. So I work in the housing development and regeneration team here at Gowling. But of course, the conversation is much wider than housing, which is why when we've been delivering training to our own cohort of lawyers internally, this didn't just start off as a housing and development talk. It actually morphed into the whole of real estate, which is approximately 1/3 the size of Gowling, really. So a really interesting topic. I'm hopefully really relevant to all of you joining us today. So welcome. So what I'm going to be looking at today, a couple of things really. The first is in relation to key risks associated with everything that Ben has really helpfully just run through. And the second is in relation to the practical implications for the land deals that you'll all be structuring and reviewing out there from this point on. This is coming down the tracks quite quickly. As Ben said, from November, we're in a new regime. We're in a case where we're going to have pre-commencement planning conditions to satisfy. We'll have 106 agreements to look at, potentially also conservation covenants. So this is coming down the track. What's the first thing we need to look at? Well, obviously, we need to be aware of for each individual development site we're looking at, whether we're buying, selling, occupying, taking an investment in any of the above, what the BNG solution is. Put simply, is it going to be an on-site solution, as Ben mentioned? So is it going to be within the red line of what is ultimately being acquired and built out? Or is it being a solution which is implemented off-site? And as Ben mentioned, off-site can mean a couple of things. It can mean a little distance from the development site, or it actually can be adjoining. And that's the important distinction to make. Or actually, are you going to be paying your way through this? And when we talk about paying, as Ben has really helpfully set out, there are a couple of avenues for that. The first is buying BNG units from a third party. And that might be a local authority. What we might find is actually local authorities looking at the areas they've got within their locality, looking at the potential actually of turning those into habitat areas and biodiverse areas and promoting those. And in the same way, of course, we're going to have clients, we're going to have landowners who are also looking at the commercial opportunities here, which arise from creating their own biodiverse areas, in relation to which they can then sell on units. And this is a really interesting stream of work for us. So already we're seeing heads of terms, we're looking at deals being structured where clients are coming to us and saying, we want the ability to buy BNG units to develop our scheme. And we're finding a way with all of that. And as Ben mentioned, we think that where we're going to end up is a comprehensive register of all of those interests. So a lot of discussions around actually how we can structure those types of deals so that those on the call that are negotiating land acquisitions in particular can be sure that they can have a BNG solution. Or as Ben says, the fourth option is actually the more expensive solution in relation to buying credits from the Secretary of State. But as we've just mentioned, they're deliberately almost priced out of the market. It's a safety net that's been put in by the Secretary of State until the BNG third-party unit market is up and running. And we don't think that's a long-term solution. So when we look at all of this, before we jump into risks, essentially, we've got clients coming to us saying, can we pay and go? And actually, if we can pay and go under a unit scheme or, and deal with this under a Section 106 agreement, isn't that the way forward? The answer to which might be in the short term, that might well be the preferred option. But actually longer term, we need to have our eye on the ball here because, will this be the way forward? Or actually, do we see the way this is running as being people wanting to end users of sites, homeowners, occupiers, wanting to occupy, be surrounded by a well-managed biodiverse environment? And actually, is that going to increase marketability? Is that going to have a positive knock-on effect in terms of price? So we think that actually in the shorter term, some of the local authorities like Warwickshire are very quick off the mark in relation to Section 106 agreements, which is great. But actually, we need to have our eye on the ball here about what kind of BNG solutions we're crafting, not just for this year, but for the medium and longer term. And I think the business models will change, arguably as the market matures. So what will we say before, any client comes to us? Well, we'll be talking about early engagement, and that's really key. Don't forget, the local authorities are finding their way on this just as much as everybody else. The pricing of all of this, how this all works. So the first thing we'd always say to anyone picking up the phone asking about BNG is early engagement with the planners to try and work out the earliest point in time when everyone can work out the timing and cost implication or whatever the BNG solution is going to be. So with that background, if we can just run through some of the key risks then in relation to how all of this fits together. Well, the first, as Ben said, is the uncertainty regarding the conservation covenant mechanism and the liability attached to that. We have structured agreements in the past, actually, which deal with biodiversity, and they're dealt with under the Wildlife and Countryside Act. And when we do those, we draft them in a very similar way to Section 106 agreements, which is helpful. So for those on the call that are familiar with those types of planning agreements, that they're the agreements that are put in place to trigger the grant of the planning consent. We often sew in release mechanisms on that. So the owner of land is released under our Wildlife and Countryside Act agreements when land is sold. But we haven't got any certainty at all, have we, Ben, that actually that's going to be the mechanism which is going to be agreed in relation to BNG, particularly in relation to conservation covenants. So we need to be really aware of the fact that we're going to be potentially dealing with lots of latent liability on the books in relation to management moving forwards. And critically, how does that sit alongside the management regime? Well, that's really important. Will end users, occupiers, homeowners be willing to pay for estate charge provision in relation to BNG, where the provision of that BNG is off-site, for example? I mean, that's interesting, the way the market's going to evolve in relation to that. And actually, what liabilities, as I just said, will developers need to keep on their books for the longer term? We're talking about 30-year plus commitments here. So while there is potential for collaboration between essentially developers and responsible bodies, we're also looking at clients bringing a lot of expertise in-house, employing environmental consultants to look at these issues. And I think that's something which we'll see a lot of moving forwards. And don't forget, of course, the sanctions are really harsh for all of this. So the full array of legal redress will be available for a breach of those conservation covenants. That needs to be taken into account very carefully. So we've dealt with the state management regime and uncertainty. What about the delay to development? Well, we're all familiar with the situation where clients have got a planning permission in place, but we all know from land banking arguments, of course, from the government, that you can't start development until all the pre-commencement conditions are signed off. And that will include, of course, BNG. So don't be fooled into thinking that just because you've got a consent in place, if you're buying land, you can build. You've got to sign off that pre-commencement condition. So again, you need to be really careful when you're looking at sites, particularly on the buying side, to make sure that that can. So we've looked at possible delays. We've looked at sites not being oven ready, essentially for development. What else do we need to look at? Well, there's obviously additional costs as well. We need to look at the potential for additional costs being required in order to unlock the BNG solution. And that is not just the management and maintenance responsibilities, but it might actually be buying in additional land. You know, how is that cost going to be factored in? And we'll come to that in a minute in relation to how we structure transactions. And judicial review, or JR as we refer to it, how is that going to impact us? Well, as we all know, there's a real risk, isn't there, that the eagle-eyed eco-warriors out there will be looking at the way in which these BNG plans are being signed off by local authorities and seeing that as an opportunity to actually bring about a judicial review challenge. And we know that because actually any pre-commencement planning condition being signed off can always be subject to challenge. So again, when you're looking at development sites, it's really important to understand there's a real risk here, arguably more so probably in the early days, to some of the solutions which are brought forward being challenged in the courts, and potentially the BNG plan, which has been agreed, being set aside and that process having to start again. And that I think all feeds neatly into the points to consider contractually. Ben, if we can just move on to the final slide. So we've looked at some of the key areas of risk, and as ever, that they come down to timing, cost, delay, challenge. That's all standard development work, really. What are the practical points? Well, the first point is beware, particularly on the buying side, where you're committing yourself to acquiring a land interest before a point in time where you've got a bulletproof BNG scheme, which is itself free from planning challenge. That's really important. And depending upon the type of transaction you're looking at, that might mean if you've got an option agreement not serving your price notice, for example, or if you've got a floating price mechanism under a contract not starting that price negotiation, until such time as you know what the costs associated with BNG are. And all of that actually leads into essentially not committing yourself to what we might call in the legal world, the unconditional date definitions in a whole array of agreements, not occurring until such time as we know absolutely what this solution is. Is it on-site? Is it off-site? Is it paying? Is it buying additional land in? All of those things are integral parts of the whole development process. Sellers, of course, might say it's development risk and over to you, but particularly on the buying side, we're seeing buying clients now being much more careful about engaging early with the local authority and actually not waiting till the very end, not waiting till they've got the planning permission, but putting all of the detail in very early on for sign off as part of the planning application itself, so that when they get the planning permission issued, they've got not just the permission, but the solution required to unlock the BNG headache that they now have to grapple with. So that's the first point. And also this is going to lead into onerous conditions, as we might refer to them. So there's a whole array of agreements again, which deal with how do you agree on the buying and selling side, what's acceptable? Well, of course, you're going to, on the buying side, not want to be caught by unnecessary costs or onerous planning conditions in relation to BNG. But on the seller's side as well, you'll need to be really careful about what you're signing up to, particularly when you're leasing in a situation where you're going to be signing up to potentially a Section 106 agreement, or a conservation covenant type mechanism, which is going to impose on you as landowner some pretty long-term conservation requirements for your schemes. So this is really going to require a bit more thought, isn't it? So if you think about it, if you're a landlord, tenant coming in, what kind of security do you require for that? That's all part of the discussion, I think, which is going to be circulating now once we're in the era of BNG, which we are. So the first point is delaying commitment to buying in land. The second is BNG costs. Well, it's an obvious point. We've dealt with actually the risks associated with all of this. How are we going to deal with this under our price formulae? Are we going to be able to deduct the cost of paying for units from a third party, or credits from the Secretary of State, or buying third party land in? All of that needs really careful thought. And particularly where you've got minimum prices as well. Just be really careful of those, particularly on a gross acreage basis, and particularly where there's fixed price land transactions. So just be really careful about that. And what about securing additional land? Well, this is interesting. So you might have a development opportunity on the buying side. It's a great opportunity, but actually seller might own additional land. Don't forget that land which might not have development merit may well have biodiversity merit. So think about, when you're structuring transactions, what ability you have to draw down additional land to unlock a more lucrative, more profitable, more costly development on the development land. So bear that in mind, please. And what about change of use? Well, people often try and limit a change of use in documents. Sometimes it's important, and sometimes less so. But actually, what we need to be doing here is thinking about biodiversity net gain. And the clues in the title, it's a net gain. So actually, if before development starts, your farmer that owns the site, for example, has turned everything into a beautiful grass meadow, Ben's very happy. He's a self-professed eco-warrior, as you can probably tell from the first part of the talk. But actually, where does that leave you if you're on the developer side? I'm here to strike a bit of a balance, really, in terms of these discussions. But that does mean, of course, that you're going to have a lower starting point, a lower base point for biodiverse calculations and metrics. So if you're not careful, what you'll end up with is a farmer doing the right thing for the environment, arguably, developer coming along and having then a greater cost, a greater liability for biodiversity net gain. That actually might come full circle and come to bite the farmer again if everything comes knocked off the price, but there we go. So what we're doing at the minute is we're actually looking at limiting changes of use in our documents. And infrastructure, well, we're all used to talking about infrastructure, roads, principal roads, POS, drainage, all the rest of it. Don't forget BNG. You won't want to be paying full development value for BNG land necessarily, particularly if it's, adjoining a development. So just be aware of how that impacts on price, and particularly minimum price if you've got a net acreage calculation. Excuse me. And be aware of implied BNG conditions. Sorry, frog in my throat. So again, even if the planning permission doesn't include the BNG condition, you're going to have actually that implied through statute. So whether we see it in the permission or not, this is coming down the line and we need to grapple with it. And the last point, commercial opportunities. As I mentioned earlier, we've got lots of clients looking at options to buy BNG units. We've got other clients who have larger landed interests. If you think about it, you've got a large landowning family. They may be entering into disposal agreements with a whole array of developers, and they may have a lot of retained land. That retained land might not have development merit, but might have biodiversity merit. So again, we're into discussions about looking at the commercial opportunities that arise from being able to sell the benefit to accessing those biodiverse areas and then selling those BNG units on. So lots to think about on the contractual side if you're buying or if you're selling. And these are discussions which we're having now with our clients, particularly on the planning process, but also actually on practical implementation. So hopefully that was a helpful canter through some of the contractual points to consider, as long as the risk. I mean, the point to note is we are in this, and actually from speaking to some of the really well-versed environmental consultants working alongside and also now in-house with our clients, we would urge everyone to try and get ahead of the game here. So it's early negotiation, not just with their consultants, but also local planning authorities. So back to Anjali.
Thanks so much. Thank you both, Ben and Ed, for lots of food for thought in that presentation, I think. So we have had a few questions through. I'm just mindful of time, so we'll probably only get time to answer a couple of them. So without further ado, the first question, which I thought was a really good question that's come in. Ben, this one's for you. So does the same principle for Section 73 applications apply to future reserve matter applications? So if your outline is granted before November and there's no local policy requiring 10%, then is there no further requirement for future reserve matters in respect of BNG requirements?
That's right. It's a good question. We've had it 3 times actually in the last 2 weeks. So yeah, if your original permission was granted outside of the BNG regime, you shouldn't be subject to BNG at reserve matter stage. However, with all things planning officer, you never know what you're going to be asked and encouraged to provide. But strictly speaking, there is no statutory requirement to produce to deliver BNG.
Excellent, excellent. The next question I'd like to ask, again, one for you, Ben. How likely is it that the 10% biodiversity net gain requirement will change?
I think it will. And to annoy Ed, the tree hugger in me hopes it does. But no, the fundamental purpose of the policy is to improve biodiversity in nature. And so I think whatever government we have in the next however many years, it has to increase the percentage if that's what it takes. I think there's a feeling at the moment amongst some folk that 10% doesn't turn the dial, and it just preserves the status quo. And actually, again, if you remember that we had that 1% sliver in terms of how we use our land, that's the sliver we're dealing with. We're trying to increase that by, the nature within that sliver by 10%. So I think it will. I think on the 30-year point, government said we will look at this, but we won't look at it until 2026. I think that's probably going to be the same for 10%, and I'm sure they'll give us a long lead in times because they know that planning takes however long to put together. So it won't be a case of we submit our applications and the next day, oh, it's now 20%. It will be incremental and we'll get plenty of notice, but I fully expect it to change.
That's interesting. One more quick question, if I can, that's just popped up from Alex, and thank you for your question, Alex. Do we need to secure planning for an offsite biodiversity site? Again, for you, Ben.
That is the $64 million question. I think the general feeling is it shouldn't. And that, well, I guess it depends where it is. But if it's in an agricultural situation, I think the feeling amongst most planners is that shouldn't require planning. There is an unfortunate appeal decision, not in BNG, but I think it was in nutrient neutrality, which said, yeah, that changes. You can't, going from agricultural to a nutrient neutrality scheme is a change of use, and therefore you need planning permission. So it shouldn't. But I can't say for certain that it won't. And of course, if you're doing extensive engineering works to develop that new offsite habitat, then yeah, that engineering works require planning permission. But typical lawyer's answer, all depends, and not easy. But hopefully there'll be some guidance on that coming out. But it's a really topical point. I'm sure that's why it was asked.
So really watch this space, I guess, is the message. Yeah. That's really useful. Thank you so much. I think we'll round things off now. So sorry if your question wasn't asked, but again, if you'd like us to follow up, then do just drop us a note with your contact details, and we'd be happy to do that. So all is left for me to say is thank you very much to both of our presenters, and thank you to you all for attending. Before we go, remember you can sign up for insights on our website. So if you go to www.gowlingwlg.com and then navigate to insights and resource, you'll be able to sign up at the bottom of the page. But thank you again, and goodbye for now.